Hi, hello, welcome to Nirnay IAS. This is Kiran and Shetty, faculty for Polity, Governance and IR. In this session, we are going to discuss one of the important topics for upcoming mains exam, paper 2 GS. That is the appointment of Chief Election Commissioner and other election commissioners. The appointment of Chief Election Commissioner and other election commissioners has become contentious issue because in last year 2023, the Apex Court of India laid down the guidelines for the appointment of Chief Election Commissioner and other election commissioners. Later on, Parliament made a law laying down the procedure for the appointment of Chief Election Commissioner and other election commissioners. In this light, Nirnay IAS want to make you to know the constitutional provisions related to the appointment of Chief Election Commissioner and other election commissioners. What are the constitutional truths about this? In Article 324 subclass 2, Article 324 subclass 2, the procedure of appointment of Chief Election Commissioner and other election commissioners is laid down. The Chief Election Commissioner and other election commissioner, if any, determined by the President, are going to be appointed by the President in such a manner determined by law made by the Parliament. That means the President can appoint the Chief Election Commissioners. The President can appoint the Chief Election Commissioner and other election commissioner, if any. Other election commissioners, as we know, it is not mandatory, it is option. It is option on the part of the Union government whether to have other election commissioners or not. Since 1993, we have been having multi-member election commission. So as of now, we have Chief Election Commissioner and 2 other election commissioners. They are going to be appointed by the President according to Article 324 subclass 2, subjected to the law made by the Parliament. Till 2023, Parliament did not make any law laying down the procedure for the appointment of Chief Election Commissioner and other election commissioners. In the absence of any law made by Parliament in this regard, President used to appoint the Chief Election Commissioner and other election commissioners on the recommendations of Council of Ministers headed by Prime Minister. The Supreme Court under Article 32, if there were any gap because of lack of law or policy of the government, the Supreme Court can lay down the guidelines with regard to the appointment of any important constitutional functionary or in any important functionary. The way in Vineet Narayan case under Article 32, the Supreme Court laid down the procedure for the appointment of the Chief of CBI. So this is how the Supreme Court can lay down the guidelines for the appointment of any important functionary under Article 32. Many of us, as soon as we hear Article 32, our mind is restricted only to the constitutional remedies. No, the Supreme Court of India has widest amplitude of powers under Article 32. Hence, under Article 32, in 2023, in the light of lack of law made by Parliament with regard to the appointment of the Chief Election Commissioner and other election commissioners, Supreme Court laid down the guidelines with regard to the appointment of CEC and other election commissioners. The President would appoint the Chief Election Commissioner and other election commissioners on the advice of Prime Minister. Prime Minister, he will be the chairman of a high-level committee comprising the leader of opposition in Lok Sabha and the Chief Justice of India. The Prime Minister will be heading the high-level commission comprising the leader of opposition in Lok Sabha and the Chief Justice of India. These guidelines were laid down in 2023 by the Apex Court with regard to the appointment of Chief Election Commissioner and other election commissioners. After Supreme Court laid down the guidelines with regard to the appointment of Chief Election Commissioner and other election commissioners, the Parliament in 2023 made a law laying down the procedure for the appointment of Election Commissioner and Chief Election Commissioner by invoking Article 324 subclass 2. Article 324 subclass 2 clearly empowers the Parliament to lay down the guidelines for the appointment of Chief Election Commissioner and other election commissioners. Parliament invoked that law and it laid down the guidelines. When the Parliament makes law according to the provision of the Constitution, then automatically it will surpass the Supreme Court guidelines with regard to the appointment of that particular constitutional function. In this regard, the Chief Election Commissioner and other election commissioners. So these are the constitutional provisions with regard to the appointment of Chief Election Commissioner and other election commissioners. Thank you, friends. Thanks a lot. I hope the session is very informative and interesting to you. Thank you. Thanks a lot.